Good afternoon. My name is John Tierpak, Executive Director of the Unemployment Law Project. With me, Ann Paxton, ULP Policy Director. We will begin with an update from Ann and followed by your questions. So please put your questions in the Q&A. Thank you.
Thank you, John. Good morning. Welcome to our weekly webinar. We have sort of an exclusive one-topic webinar today. It's going to be on the re-implementation of the job search requirement, which we found out about last week. This has been suspended since March of 2020. People have not been required to do the normal job search. That's always been in place because of the public health emergency. So because the state is reopening as of June 30th, this is certainly related to the re-implementation of the job search requirement. However, we don't know exactly when all the restrictions will be lifted in the state, so there's not complete abandonment of all the restrictions. So the governor is saying he could lift all restrictions earlier than June 30th, but that doesn't mean the end of the public health emergency. Well, the reason that's important is that there are provisions in the law that relate just to the public health emergency. But let me start with the sort of basic news about what does the job search requirement restarting actually mean. So we know that it was started, the suspension of the requirement was started last March. And this, what happens is if you don't do your job search under normal circumstances, if you fail to comply with the requirements for actively seeking work, you lose all benefits for the weeks during which you were not in compliance, and you become liable for repayment of all the benefits. So this is going to have significant implications for people who may be getting overpayments now that the requirement is going to be starting up. So it starts as of July 4th. The job searches are expected to be conducted that week for the first reporting, which would be a week later, July 11th. So ESD has not been monitoring job search activities. They say, although there's been some communication difficulties about whether people are required to do job searches or not, but they have not been since March of last year. But what it means in terms of, what does it mean in terms of what you must do? So if you're receiving benefits after beginning July 4th, you will need to conduct at least 3 job searches a week. And you're required to log a combined total of 3 employer contacts or WorkSource or other approved job search activities each week. So there are some changes in the requirements. So there used to have a lot of in-person contacts were required. In some cases, you would have to go to the work search offices. Well, those offices have been closed since the pandemic began. So there is a more liberal interpretation, a broader interpretation of what would qualify as the kind of search that would be considered acceptable. So you must be registered at a WorkSource office or American Job Center in your state, and you can, when you do your 3 required job searches, you can post that on your online account when you file your weekly claim. Or if you file on the phone, you can use a paper job search log, which ESD says it makes available. The interesting thing about this year is that there are a lot of new ways to meet the job search requirement. So it's not just contacting an employer to inquire about an opening. That's obviously a good one. And if you file an application, if you have an informational interview, follow-up conversation, or an email with an employer, all of those would count as a job search contact. But other things will also count. You could upload your resume to WorkSearch and make it searchable for employers. That would count. Participate in a virtual workshop at WorkSource. You can watch a labor market information introduction video online. You could also watch an online video on, say, YouTube, and it doesn't even specify what type of company is producing the video. if it concerns a job search topic such as how to write a cover letter, resume writing, or interview skills. Also, if you establish an account at LinkedIn or Indeed or one of the other job search sites, that would also work. Or if you complete an online interest inventory, such as the Strong or the Myers-Briggs assessment. So those are all considered acceptable searches. And as I say, that would be reportable in your weekly job claim, either online or through the online search log. So the penalties, as I mentioned, for failure to search would be suspension of your benefits and possibly an overpayment. So the important question for any claimant doing a job search and continuing to qualify for benefits is obviously availability. Are you actively seeking work? Are you available? And are you physically able to do the work? So those are required, but you are only required to keep your availability, establishing your availability. You're only required to accept suitable work. So how is suitable work defined? Work in the statute for unemployment benefits, suitable work is defined as work in keeping with your prior training, experience, and education. So that is a general overall take on what suitable work is. But there are several other factors that go into determining whether work is suitable for you. What is the degree of risk to your health, safety, and morals? What is your physical fitness? People who have a disability, many types of work are not considered suitable to them. How long is your unemployment continued? That's not necessarily how long you've been claiming benefits, but how long you've actually been unemployed. That relates to what work is considered suitable, because that category expands. You're expected to consider different kinds of work the longer you've been unemployed. What are the prospects of getting work in your customary occupation? How far is the job place from your home? And other important factors, including state and national emergencies. And this is a good time to bring up a bill that just passed this year, SB 5061, which starting in April made it acceptable for allowed people to be available for work if they had a high risk of contracting COVID during the public health emergency from the work site, as long as they could work remotely. Or if they had somebody at home that they lived with, a resident who was at high risk, that would also allow them to either quit or to turn down a job. So that would make it unsuitable work. That may only be in place, however, for a short term, because the public health emergency may be lifted. But as the governor has said, there is no fixed date when the public health emergency may end. It depends on the progress of the vaccination campaign and the level of infections that have occurred. So if there's different categories of suitability depending on what your job background is. For example, if you have no experience or training, then you're asked to take any work that you're physically and mentally capable of doing. If you're part-time eligible, which is a category for people that you can set up your eligibility in that category if you're looking for work that is 17 hours a week or less. Agricultural labor, if you work in agriculture or if your base year includes agricultural work, you are expected to take any agricultural labor available from any employer. So not just fruit, it might be wheat or some other product, some other crop. And victims of domestic violence, there are special suitability provisions there, so that people who may have needs to keep their address secret, for example, because they're being stalked, they set special requirements for suitable work in those cases. Interestingly, if a work that you were conducting at an earlier point in your career that was suitable then may not be suitable now. It could become unsuitable if you're no longer physically able to perform the work. And that includes situations in which where the nature of the work changed and the claimant cannot keep up with the changes. So there are provisions for situations where those would not be considered suitable work. Interestingly, also, the job titles can vary from industry to industry for kind of very similar work. So in order to establish what would be comparable based on your work that's in keeping with your prior experience, the Employment Security Department looks at the actual job tasks, the duties, the abilities, and the skills needed, rather than the job titles per se. So similar job titles in related industries are considered your usual occupation unless there are substantial differences between the jobs. Reemployment with a former employer is considered suitable work unless the claimant had a work-related reason for quitting the job, and the refusal to take the work is for the same work-related reason. And temporary employment is suitable for claimants without good prospects for obtaining permanent employment if you've already been unemployed for an extended period of time. Job seekers are allowed to limit your job search and your availability to a preferred occupation for a reasonable length of time. That's the wording. But it doesn't make other occupations unsuitable if the claimants have the training and experience to do that job in the other occupation. And claimants will be denied if they refuse a job simply because they prefer another employer or occupation. If you have good prospects for obtaining permanent work, you are also not required to take temporary work if it would limit your prospects for getting a job, a full-time job, a permanent job. If you dislike a customary occupation, you've never liked it, for example, that is not considered a way of making work unsuitable or an excuse from seeking work in that field. And there's some exceptions that is important to mention. Work is not suitable if the position is vacant because of a labor dispute, such as a strike. The wages, or also if the wages, hours, or other work conditions of the offered work are substantially less favorable to the claimant than those prevailing in the locality. That means the local labor market. So if the prevailing wage for a certain occupation is $18 to $22 an hour, and you receive a job offer at $17 an hour, you, according to the Employment Security Department, you are not required to consider that suitable work. You're allowed to continue searching for work that is suitable. If the employer tries to impose a requirement that you belong to a union or that you not belong to a union, that is also considered a work that is unsuitable. And as I mentioned, public, state and national emergencies are other conditions where there's exceptions to the suitable work provisions. If the work is found suitable for a claimant, the adjudicators at ESD will examine the reason that you turned down the offer, and if the work was not suitable, then the refusal does not disqualify you for benefits. And in those cases, the adjudicator will write a formal decision, which can be appealed. In theory, they will write a formal decision. We don't always see that happening, but it's something that is supposed to happen. So just a little bit more detail about the issue of refusing work. So there are 3 elements that you have to meet in order to for a job to be considered a bona fide job offer. So first, there has to be a genuine offer of work or referral to work that was successfully conveyed to the claimant. Second, the offered job has to be suitable. And third, did the claimant have good cause for turning down the work or the referral? So there's no issue about refusing work as a bar to receiving benefits if you don't claim for the week in which the job refusal or refusal of a job referral occurs. If the week is claimed, it must be an otherwise compensable week in order for the Employment Security Department to write the decision. There's no issue if you're making satisfactory progress in a program called the Commissioner Approved Training. So that's not a very large contingent of people, but those people are receiving training benefits, and they do not have to be available for jobs that are offered. There's no issue if the offer was not bona fide or if it wasn't conveyed successfully. And there's no issue if you set up an interview with an employer and you don't show, as long as the work source office didn't set up that interview for you. In those cases, then you would be considered to be refusing work that might be suitable. That would seriously put your benefits at risk. But if you fail to attend an interview because, say, an emergency came up or you're ill, that would not be considered a refusal of suitable work, but it might put into question your availability. So that's always an issue that you need to keep in mind. Many things are excusable at the point where you're getting a job offer, but they may get you in trouble later because you may not be considered available for work. You can establish good cause for refusing work, but if the reason for refusal, it could result in a denial of benefit reduction due to not being able or available to work. You may know from people who have appealed their denials of benefits that the Office of Administrative Hearings always includes availability as one of the issues it will address. And so that's the issue of job refusal will consistently come up when you have an appeal, if you're considered not available and it relates to a job refusal. So it's important to know the rules about suitable work and about refusal of work. So just a couple of instances of things that are not considered bona fide offers of work. And there's a lot of confusion about this. And if the employer says, yeah, we've got some extra work, are you interested? That's not considered a full bona fide offer because it doesn't give a specific job title, and it doesn't give the details, which will include the duties, the starting pay, and the hours of work. Those have to be conveyed to the claimant. For example, if the employer sends an email and you don't receive it, that's not considered successfully conveyed. Say you don't receive it in time to accept the job offer, for example. But you must contact or make a reasonable attempt to contact an employer who offers a job to verify that there is a bona fide offer and verify the terms of the work being offered. So you can't just kind of write it off because it's not specific enough. You're expected to continue the decision-making process based on available information if there's no response from the employer. Another thing that might be makes a job offer not bona fide is if it's contingent on passing a test or passing a background check. For the purposes of unemployment insurance, that is not considered a bona fide offer of work because it's contingent. So the suitability of the work directly connects to your ability to refuse work and survive an availability review. And we have a lot of other reasons why there would be good cause for refusal. ESD has made many rulings on these issues over the years because it's a constant issue with every single claim. So I won't go into a lot of those details right now, but we can make more details available on our website. And for now, we can answer questions. So that's the major news this week.
Thanks, Ed. I would like to add a few points about this. People often ask me, well, am I being forced to apply for jobs that I don't want, that are far away? And, if you're keeping that job search log of 3 reasonable job search contacts, people you've sent a resume to, people or an employer you filled out an application from, as long as you're fulfilling that requirement, you are not going to get in trouble. People say to me, well, I live in Seattle and I don't want to go over to Bellevue. Well, Bellevue's in the job market. If you applied for a job in Bellevue and turned it down just on the basis that it was far away, that would not be a good refusal. So focus your job search on where you live and areas. Now, areas you are working in. Now, uh, there's a mention of like passport. You have to do suitable job search within, you know, related to passport. Well, what if you want to go off in a new direction? Nothing prevents you from looking for any kind of job anywhere. But if you want to kind of stay out of trouble, let's say you've been doing work as a medical assistant and are skilled in that, you're qualified for that. It would be it would be uh, it would be important to make applications in that field and maybe do those 3 applications a week. I lost my screen for a second. Um, and then you can do 5, 10, 20 job applications in any other field you want to. It doesn't prevent you from pursuing a new career or going into a new direction. Um, and we've been talking in general with the 3 job searches a week, and it's good to hang on to, if you're keeping paper records of these things, hang on to them for a long, long time, because they, I would say at least a year or more, and keep them in a safe place, because they do contact people for random job search reviews. And you would expect to have those records. Also, even if you have quit claiming, let's say you applied for unemployment for only a few weeks or a couple months and you went back to work, that they can still ask you for a job search review, which could lead to an overpayment. So it's good to follow your notices and messages from the unemployment office, even after your claim has uh, been closed, as far as you're concerned. And I think while the focus of this discussion is on the category of most claimants, which is having to do the 3 job contacts a week documented, actual contacts of different employers. Um, there are other categories, and referred to being in a full referral union. So if you're in a full referral union, and not any union, but only the kind of union that sends you out on jobs, your job search requirement can be satisfied, but by being in good standing with that union, being on their out of work list. Also, and referred to uh, commissioner approved training. Commissioner approved training is a program that it's not any education, it's approved educational programs through Employment Security Department, would allow you to, rather than do a job search with contacts, just participating and getting passing grades in those classes you're taking would qualify as your participation in the job search. But it's very important, because some people get a little information on this and run with it. They think, well, I'm in school, I don't have to look for work. In fact, being in school can be a reason for being denied regular unemployment, because you're not considered fully able and available for work if you're not willing to either quit your classes or to adjust your classes, or are taking online flexible classes. So that there are pitfalls there to be aware of. And the final thing I would like to mention is uh, there are still rules about standby. We heard a lot about standby early in the pandemic, because a lot of us, including myself, believe this would not go on very long. And so employers place people on these temporary standbys. And a person on standby, officially on standby, again, it's not something that you could just say, I'm on standby. It's something your employer tells Employment Security that this worker will come back in 3 weeks or 4 weeks or 6 weeks. And I'm forgetting, Ann, do you know what the maximum weeks of standby are these days? It might be 6 or 8 weeks, something like that.
I don't know.
Okay, it's very short term, and it's usually used where an employer has like a temporary shutdown and they want their employees to come back. That employer doesn't want those good employees to get other jobs, and go somewhere else. So they want them to come back in a few weeks. So be careful if you're hearing the phrase standby, make sure it's approved by your employer and on. So we will move to some questions now. The first question is about substitutes. Promised future employment in the fall. Are we eligible to apply for unemployment in the summer, as well as apply for 3 jobs a week? Normally, a substitute is not entitled to unemployment in the summer. If you are claiming in the summer, if you're a school employee, normally school employees do not get unemployment in the summer. It's a complicated issue on a case-by-case basis, depending on the job, what the school district did as far as reasonable assurance. It's a very, very complicated case-by-case issue. But if you're applying, keep that job search log and to make those 3 individual job search contacts each week, and whether the issue of reasonable assurance will be played out. If Employment Security finds that there was not a reasonable assurance, they would grant benefits, and the employer, the school district, could appeal. If the school district, if the Employment Security Department found there was reasonable assurance and you're denied, you can request a hearing, and there may or may not be an overpayment involved. These are very individual cases, depending on the school district, what their communications were and what the situation was. Let's see here. Another question here. Also, as a sub who normally doesn't get paid for various breaks, including spring and winter breaks, I could not file my claim unless I said I didn't work. So I claimed the recent spring break. They said now I owe them for that week. So it's a question of whether to appeal it or to pay it back. So it's a personal choice. If you have an overpayment and you can pay it back and want to resolve the issue that way, that is fine. If you appeal it, a judge could look at whether, if there's an overpayment, whether a person was actually eligible during that period. In this case, probably not, but they could also consider a waiver of the overpayment, that the person, if the person's considered not at fault for the benefits, and it would be a hardship to repay. Some people go through that hearing process about that issue. They find it's worth it and worthwhile. Others don't. If you do have a hearing coming regarding an overpayment or anyone or other banal issues, you can contact the Unemployment Law Project for help. And anything else to add about those issues?
No, these issues with substitutes are very complicated, and it's actually difficult to know how the rules are going to be interpreted. However, if you're not filing for unemployment benefits, there's no job search requirement imposed on you. So if that's where your situation is, you shouldn't feel that you're subject to this. But when you are claiming benefits, then that's when you need to comply with the 3 job searches after July 4th.
So I have a question about job search contacts and what best constitutes a job search contact. One of the issues that has come up when people have been contacted for job search reviews is people who provide a job search history that is not really job applications or not really job contacts, and also asking or reapplying over and over to the same employer for the same job. And the question was, what is a good job search contact for unemployment purposes? My opinion, having just observed all these issues for years, you can make all kinds of job contacts. You can network, you can hang out with friends, you can call up employers randomly, send emails inquiring about work. But in my opinion, is the best most solid job contacts are when you actually send a resume or fill out an application for an actual employer with either a job posting or a realistic possibility that they might be hiring. And I say that because um, you have to look at what's customary in your field. There are some types of jobs where you rarely see a job listing, a job posted, but in your field, you may be aware that in your region or where you live, that there are a number of employers that do that kind of work, who are hiring off and on, but maybe not posting jobs publicly. So making that affirmative application, sending the resume or filling out an application online or any other way would be the best to have that sort of solid thing. Now, there are other contacts, other things that Anne had mentioned to sort of broaden what constitutes a job contact, but those are the sort of safest and easiest to document in terms of making a job search. And would you like to add to that?
No, and just the key point is that there's so many more job search activities you can do that are virtual now. So really physical contact with prospective employers is not required. And that used to be a big component of what might be expected to do with a job search. There was a question in the Q&A about whether high-risk older adults are required to look for work. I'm on PUA. What are the exceptions for this population? Well, right now, the public health emergency is still in place. So that means that SB 5061, which did set up an exception for people who are at high risk of contracting COVID or who live with somebody at high risk from complying with the job searches, and allows them to quit a job and refuse a job if it would put them at high risk. So that's an exception for that population right now, but that could change really any day, probably after June 30th. We just don't know. That exception may not continue very long, so we'll find out.
Okay, so we have a question here. A person says that UI wants me to reapply. Hearing is supposed to be with the Office of Hearings around July 4th. I have until June 24th to reapply. What should I do? I'm not clear on what the reason for the original denial is. If you have an opportunity to reapply, I think it's good to approach things from a number of angles. So, for example, reapply, give them any information. It could be that you might be eligible for a different program. It's hard to tell without this information. It doesn't hurt to reapply or fill things out. If you have a hearing coming, you can always do the hearing. If something is resolved prior to the hearing and you're 100% sure, you can always withdraw the hearing request or go to the hearing and tell the judge that it is resolved. So there's no harm in applying or reapplying. And
right.
Anything else?
Exactly. And we always try to advise people on when they're trying to decide what to do here is leave as many options as open as you can. So if you have until June 24th to reapply, you should do that. Don't wait for the hearing and foreclose that opportunity you have to reapply. So I think that's the best strategy. We really don't like to see people lose their appeal rights because it is hard to get establish good cause if you have a late appeal. That's the process you don't really want to get into if you can avoid it.
There's a question, where can I get a hard copy of the job search log paperwork? It's somewhere on the ESD website. I remember a while ago looking for it. They used to give what's called claims kit. They used to mail this booklet out to all the claimants. If you look for the claims kit, I think it would be in there. It's a form which kind of breaks down weeks and has little boxes you can fill in for information, contact the employer, who they are, like what their address is, for example, and then what type of contact you made. That should be available through the website, ESD. Okay. Okay, I have a question. Again, another job search question about if I apply for a job and then find out that the pay is too low, do I have to take the job? Answer is no. That would be unsuitable if your past pay or thing would that would not be a problem. One of the problems sometimes when somebody refuses a job is you know, like, well, why would you apply for a job that pays so low? But what I've learned is that many employers will not list a pay rate in their job listings. And so often people apply for the job and only find out what the pay rate is when they're being actually offered the job. And so it is understandable, like if you've been making $30 an hour for years in your field, and then you get a job, where they're offering you like 17 or 18 an hour. There might be reasons why that might be wise to accept that, depending on how long you've been unemployed or opportunities for advancement at that company. There's other things involved why that might be good, or if you're shifting careers, you probably can't expect to come in at a higher pay rate of somebody with more experience. But you can refuse a job offer if the pay is substantially less than your prior work in the field, and just indicate that when you claim benefits that you refuse a job offer, and they will ask you why. And chances are it will be found to be an unreasonable job offer for you, and it should be okay. If not, if they find that you should have accepted the job, you could always request a hearing. If they cut you off because of a refusal of a job, it's important to keep claiming, if you will be appealing it, to keep claiming for all those weeks up until your hearing, because the job, because if it gets reversed at your hearing, you will get paid for those weeks. Let's see. And anything else to add to that? Others?
Yes, we've received questions about what can people do if they have, a lot of people have trouble with childcare issues right now because schools are not fully back online, fully back in person. And they have run into difficulties with accepting various job offers. So the question was what are the requirements if they receive a job offer and have to refuse it because of childcare issues? We've been working on this issue for quite a long time to try to get better provisions for, especially for any caregivers, childcare or vulnerable adult caregivers who have reasonable conflicts with potential hours of work that might be required. That puts their availability into question and can often get them into trouble with denial of benefits or having a substantial overpayment. So ESD has said that actually for refusing a job, so-called personal and compelling reasons may establish good cause. So that reasons could include, for example, illness, lack of transportation, or lack of childcare. You must show that you took all reasonable steps to try and resolve the problems that prevented you from accepting the work. So here's an example. The claimant refused a job offer because her regular babysitter was not available to care for her child. She was unable to find a temporary babysitter. The claimant had a personal and compelling reason to refuse the work and was able to establish good cause. So that's good cause for refusing work, but it might put this person make this person subject to a denial of benefits for not being available for work. So those are two separate issues. You may be able to establish good cause for turning a job down, but that will not necessarily solve the issue for you if you're denied for benefits on the availability issue. And this is something that comes up so often. Both we and ESD have been working on solutions for this that we hope we'll see some progress in the next year, and possibly in the next legislative session we'll be introducing some more another bill.
And one thing that has been problematic is now we have the paid family medical leave since January of 2020, and we get calls from people who are working now having medical issues, and some employers advise people to quit and apply for unemployment. And I don't know whether these employers really know what they're doing or not, if they're intentionally wanting to lead people in the wrong direction. But if you're in a situation, again, it's not, if it's pandemic related, then there's the PUA, but in general, for regular unemployment, if you have this medical, sort of ongoing medical issue, and it's probably better to go with the paid family medical leave option, which would be up to, I believe, 12 weeks of a benefit if you're not able and available to work, if you can't work, and that's what it's for specifically. And that getting that benefit would not require a job search, not require you to look for work or be able and available for work. And that would be a better option for most people. It's confusing because there are many programs out there to assist people. Unfortunately, there's not like one-stop shopping where, you know, if you can go to like one government agency and they can either find you fit into unemployment or Social Security or paid leave, medical leave, or other categories, unfortunately have to navigate. And a lot of people are sort of in the gray areas, you know, where they have disabilities, but yet they may be able to work. And it's often, you know, hard to figure out what category of a public benefit would be best. But definitely people should be aware in general, whether it's for yourself or people you're working with or advising, that the paid family medical leave is there. And it may be appropriate in some cases. And anything else?
No, that's definitely something to keep in mind. It's a very strong benefit program. It's been very popular. First year reviews are very positive. So paid family medical leave is certainly something to keep in mind.
And I have one more question. And again, we're on the topic of the job search, and I think we've referred to this. If I'm keeping my job search on paper, how long should I keep it? And I believe somewhere in some ESD manual, I think they recommended a year, but I would recommend a couple years. Put it with your important papers, your tax returns, or other important papers, just because they can have that job search review. One of the things that was very confusing at the start of the pandemic was when I heard that they were going to suspend the job search requirement. I assumed first that they would assume being able and available for work as well. That, of course, is not true. And it created a lot of confusion for people who were asked, are you able to work? And they would say, no, I'm not able to work because my whole field I work in is shut down completely, so I'm not able to work. But the question means, like, are you physically able to work hypothetically if you did have a job? And one of the reasons I thought suspending the job search and the job search reviews was a good idea was in 2020 with the overwhelming number of claims for unemployment. it would not be a good use of resources of employment security staff to have people checking job search logs while thousands and thousands and thousands and thousands of applications were not being processed. That it would be an appropriate shift in resources to processing applications rather than focusing on people searching for work. I don't know what this new policy will mean in terms of that, whether the department will shift staff that's much needed in processing applications, which there are still thousands of applications behind right now. If they will shift people over to checking on people's job searches, but that may happen. So it's important to be ready for that and not face potential overpayments, which would be a great hardship. And anything else to add before we wrap up?
Only that, the system, the employment security system is set up to be somewhat biased on behalf of reemployment. So benefits don't get as much attention, they don't get as much funding. And in this last legislative session, for example, as John is kind of suggesting, we tried to look at ways to shift resources. When you have a recession or a public health emergency, you don't need, and workforce offices are in fact closed. Reemployment is not really the priority. Getting benefits to people who are needing them should be the priority. We tried to talk to legislators about shifting some of the resources that would go to WorkSource over to answering the phones, getting those benefits, benefit applications handled. But there are apparently firewalls that prevent that from happening. So reemployment is a very strong priority, and we'd like to see it we'd like to see applications and approval of benefits be at least on the same level. Not quite there yet.
All right. Thank you, Ann. And thanks to everyone who participated today, and we will be back next Monday. Thank you very much.